Good evening, everyone. My name is Ritwika Sharma, and I'm a senior resident fellow at the Vidhi Center for Legal Policy, leading Charkha, Vidhi's research center dedicated to constitutional law. I would like to welcome you all today to day 3 of Vidhi's Constitution Open House. I'm delighted to have with us Afreen Bano Khan, who is part of the first cohort of Samvidhaan Fellows at Vidhi. Afreen is a practicing lawyer based out of Mumbai and is currently litigating before the Bombay High Court. She has worked on a spectrum of issues pertaining to human rights and access to justice in the interiors of Jharkhand and West Bengal. Most recently, Afreen has been selected for the International Visitor Leadership Program for the year 2021-22 by the US Department of State for her work on human rights and criminal justice. So congratulations for that, Afreen. As a Samvidhaan Fellow, Afreen studied the impact of the Citizenship Amendment Act 2019 on Indian Muslims and unearthed the constitutional law issues it entails, with the eventual aim of developing a more informed and a more empowered citizenry. Afreen, we are delighted to have you with us today for discussing your work on and around the CAA, and a very warm welcome to you from all of us at Vidhi. Given that we have around 45 minutes for this discussion in terms of format, I'll start with a short Q&A with Afreen, during the course of which she can take us through key aspects and findings of her research. For everyone in the audience, please feel free to type out your questions in the chat box. I will keep taking some of these questions as and when the opportunity arises. In any event, we will set aside around 10 minutes for questions from the audience at the end. So I urge you to send in your questions as and when. So let's jump right into it then. An abiding memory of what followed the enactment of the Citizenship Amendment Act of 2019 is that of widespread protests against the law in several metropolitan cities across India. The sources of my information or the information of my acquaintances or my colleagues were mostly daily news updates or social media. Afreen, you've actually been on the field and interacted with vulnerable communities and individuals who stand to get tangibly affected by the implementation of this law. Afreen, I would like to hear from you what your research is about and what questions or concerns are you trying to address. In doing so, I think for the benefit of the audience, perhaps you could also touch upon what the CAA 2019 mandates and the major changes it brought about in the citizenship law. Over to you, Afreen.
First of all, thank you so much, Ritwika, for having me and providing me the space to have this conversation. And thank you for the question. It was actually quite exciting times when I was in the fields once again, studying the impact of CAA at the grassroots, as the Samvidhaan Fellowship was about promoting constitutional culture in the grassroots. I'll take a step back and would like to speak about what exactly inspired this project in the first place. So for the past couple of years that I've been working, I've actually been in the grassroots as a researcher, as a lawyer, and so on. So for me, when this opportunity of Samvidhaan Fellowship came, and I was thinking about the Citizenship Amendment Act, because everything about it was so palpable across the country in various forms. Say the protests, like you mentioned, whatever happened post the protests, what was the state mechanism, what was the state response, what was people's response, and in all of it was not possible for me to unsee the last person possible because of all the ground experiences that I already had. And I was constantly worried or anxious about, the implication of the NRC, because that is the prime problem when we talk about the Citizenship Amendment Act, other than the very problem of including religion or excluding them, like the Act has mentioned. So for me, it was important. And in fact, when I was writing the proposal, I was actually coming back from the courts every day. And it was again impossible for me to unsee the documentary regimes and how they play out in the courts on a daily basis, because I would bail people out, but people would still be languishing in the prisons only because they were unable to produce those documents required, as surety, and the whole labyrinth of documentation. And that would simply keep me anxious about what the NRC is going to entail. So this is where I put in together all the experiences and the of a practicing lawyer, of being in the fields, of being from Eastern UP myself, and being in other interior parts of India, and how it plays out. So it was important for me to understand this particular aspect and how does it impact particularly the minorities, because it was obvious and it has been obvious throughout since the Amendment Act has come, by the explicit exclusion of the Muslims from the act, and is why it was important to put our focus on that aspect and see where the law goes and what it brings forth, and what we could as lawyers and researchers do about it. So this is more or less where I started my project with. And the major changes, like I said, it was the exclusion of a particular religion, and especially the countries that they have mentioned, Afghanistan, Pakistan, and Bangladesh. They are supposedly Muslim majority countries. And while it would immediately be understood as an affirmative action for the people persecuted there, we failed as a generous and magnanimous country to include all the people who are persecuted in these particular countries. And then coming to this idea that our affirmative action should be for people outside our own country and not for the people within the country borders, that is to me quite an antithesis of the affirmative action itself. So yeah, this is all put me forth to do the project the way we did.
Right. Afreen, I will have to say that it's rather heartening to hear from you what inspired you, what led you to work on this project. You also mentioned the aspect of the last person possible, and that intrigues me a lot. Now, I'm very interested to hear more about your research methodology, especially because I know there's a certain ethnographic component to it as well. So please clue us into that, the research methodology of your project, especially the process of sampling and identifying your interview participants when you set on working on the ethnographic component. Please.
So Ritwika, because we have been in conversation about this throughout the year, right? And when we set out, I was not very clearly looking at it as academic questions, because I wanted to, in some way or the other, and like I mentioned, the kind of work I've been doing, for me, it became important that the abstractness of the Constitution translates to tangible implications. And that simply made that I am, first of all, there, available and present in the fields. But during the time, it also became important for me to focus my questions in terms of answering those questions in more specific manner, is when we started looking at all this ethnographic aspects and who exactly should we include. Because last person possible, yeah, it could be just anybody. Ours is a huge country, billions of people, 5 states that I was traveling into, and the number of people that I was questioning. But it was important that I include the people who will be perhaps left out, even if, say, there is a common understanding or a common community feeling developed at a grassroots level. So mostly the subalterns, in a way, if I could put them in that bracket, because I am talking about a particular village where there's not even electricity till date. And these are people who often travel outside their village as migrant laborers to all these metropolitan cities, and people who have to consider where the next meal is going to come from. So that's what I mean when I talk about last person possible. And then also it became important for me to include all kinds of people within that strata, say number of women, and what kind of women. Are they all working women? Are they daily wagers? Are they homemakers? How is it impacting everybody differently? Is there anybody with physical disability who might have some problem in accessing the tools of accessing citizenship in the first place? And there were old people, because the older generation might be perceiving all of these differently, also in context with whatever they might have in terms of documents. And all of this was very much inspired by our understanding what has happened in Assam. So everything was somewhere feeding in our collection and our outlook at the ethnographic uh, point and inclusion that we were trying to do. So there were people, and also when we were talking about these people, it is not just migrant laborers. There are people who are also who stay back in the villages, who are somewhere the village level entrepreneurs who have been given this license to prepare the documents for all the for the citizens, and there were private agents who make these documents. So when we were talking about, we are looking at aspects of citizenship in terms of how they understand the law and whether they have all these tools and mechanisms to access the citizenship, as I mentioned. And it comes, everything boils down to documentation. Okay. So as we understand things today, documents are needed to access every any single right. I mean, even the most basic of them. You produce this document, therefore you are able to access this. You produce that document, so you are able to access that. And this is the main research question. Then that is how we were able to decide the ethnography of it. Yeah, although we did rural and urban both, but we questioned people in Maharashtra also, which was mostly working class, but a bit more like in the middle class strata, and a few of them educated, a few of them having some experience of whatever must have happened in the city, and but mostly of the Muslim community. Although we did include people from the Hindu community, so that in order to assess and understand the implication of documentation across a spectrum, whether it is whichever community you come from. But for some reason, and as the sensitivity of the topic attached and so on, a lot of people did not want to be interviewed or were not comfortable to be spoken to about this. So yeah, this is what has on and off and majorly fed in what we have been able to do.
And my understanding is that the reluctance of people to speak also sort of is again a palpable impact of the CA, of the law itself, and the sort of feelings it creates amongst people. I'll probe a bit further on the research methodology. You mentioned that you interacted with participants across certain states, if I'm not mistaken, across 5 states.
Right.
So what idea went behind this selection of states, or more accurately, what idea went behind selecting certain cities within states? Were you what lines, along what lines were you thinking?
So first of all, Ritwika, it was I wish it could have been the whole of the states, but the states itself, they themselves have a demographic dividend, right? I mean, Bombay part of Maharashtra is not the same as the eastern part of Maharashtra, and similarly for UP, and so on. But it was, and also because it was a year-long project, we had to be centered around some place. But it was also at the same time important to have a holistic view of what is happening across the country. And what we have seen in Assam, say in terms of people being declared foreigners with no proper justification, and all that has happened since then, it was very important for us to look at what is happening, because is it the same mechanism that is going to be implemented in the rest of the country, given that the rules to the Citizenship Amendment Act are yet to be framed? And as we hear, they have asked for an extension for the 6th time, right? So we are still in a limbo. But what do we understand of something that has already happened or is already happening, and take cue from that there as a lesson to what we could perhaps be able to mitigate in the rest of the country? Although it is a very ambitious a call in a way, because we don't know what the government is going to come up with in terms of the rules and the notifications thereon. But what we can see in foreseeable human limits is what we are trying to mitigate. So therefore, Assam was the lesson, and how the foreign tribunals function, which perhaps you would be hearing more from my fellow colleague Padmini tomorrow, but and other implications that that it has, say, for example, on somebody detained or somebody who has not been able to produce a link document, or say somebody who has been declared a foreigner just at without any justification in an ex parte order, right? So all of these things, it was important for me to understand so that I'm able to talk about it or look at it panning out in the rest of the country in a better way. So that was one, and therefore West Bengal, considering Bangladesh and border and the language issues there, and all this Bangladeshi Muslim and Bengali Muslims confrontation that keeps happening all the time. It was important for me to look at that aspect. New Delhi, because of the whatever happened, the whole set of protests and the understanding of its constitutionality in common parlance, it kind of started with all these protests, and they started translating it to common language. So it was important for us to look at Delhi as well. Uttar Pradesh happened because we couldn't take Bangalore into account. Bangalore, because the underlying understanding is that different set of governments in different states have different mechanisms played out in implementing laws. And for me, it was important to include the southern part of the country in some way or the other. Bangalore being one, because we do have marked immigrant population there. So it, which did not happen for obvious reasons of the pandemic and the second wave and so on. And but then it nevertheless translated into something better, because then we were able to look at the UP East region, and especially the border region, as to how something like this, which is already such a huge issue in the country, how is it taking into account the people at the borders, like literally at the borders. So yeah, that is how. And Maharashtra, because I'm based out of Bombay, it was important to look at a state or a region which is considerably more nuanced in a way, in a common man's understanding, like we understand it to be. That could again debatable, but we all understand Maharashtra to be a place where people are more aware, or people are more, people have more accessible services and so on. So yeah, so this is how we were able to choose the 5 states like we did.
Right. Thanks for that, Afreen. You've briefly touched upon this already, but I would like you to spend some more time to just take us through your key findings. And in doing that, I think it'd be very helpful if you could reflect on two things that I think are quite crucial to this discussion. First is, as part of the ethnographic research, and when you were speaking to your interview participants, what was their understanding, or how did the participants understand the CA, the Amendment Act? What was their understanding of the law? At the same time, and this is my follow-up question, what is their understanding of the Constitution? Do they perceive the Constitution, if at all they do, as the instrument that can potentially protect them from the discriminatory conditions that might emerge from the implementation of the CAA? What are your thoughts on that?
Yeah, so Ritwika, here's the surprising part. What we generally understand is, even when we talk in terms of last person possible and all, we understand that they are completely unaware of the Constitution. That's not true. They know there is something that guides their rights. They know there is something that ensures them their rights. It's just that they don't have the tools or the of course the training to translate it or articulate it in the way, say, for example, literate people would do. Okay, so that was very heartening to see, although it also differs from people who have the level of education they might have had, class 2, class 3, standard 5th primary school education, but even that gives them that much of power. It is also about then the accessibility they have to the current information regimes, say for example a smartphone through which they have access to multiple other things. Now, other thing to look at is how many people do have smartphones. Is it all the men who have smartphones, or is it all the women also who have smartphones, and so on? And what is the income bracket that they fall in? How many? I mean, that is one of the considerable parts too. So while they are able to understand that there is some right that is just the absolute right and nobody can touch it, there is a lot of anxiety, certainly, because they are also unsure, and they are unsure for the reason that what they see around, is this very palpable shift of behavior of the communities that have coexisted for the longest of times so peacefully and so well. Suddenly there's some sense of hostility around, and that is where the anxieties come from. So while they have hope in something, some superpower, say God, and that nothing will happen to them and God will make it all right. And there is something like the Constitution, because they have then faith in the country and the Constitution. And simultaneously, they are also bombarded with this anxieties of behavioral patterns around. So they kind of feed in each other, and this makes their daily lives. This is what the CA has done, I think, in the long run, or maybe the implications of which are going to be seen in the long run.
What you just said, Afreen, actually makes me both happy and sad when I think about the Constitution and its reach. But I'll just probe you again a little further. You've already spoken about this, about the fact that citizens do have a certain level of awareness about the Constitution, but perhaps not a nuanced understanding. Evidently, the pool of participants who you spoke to spans across people from different socio-economic backgrounds. So again, you've alluded to this already, but could you just spend a few moments on how does this difference in socio-economic backgrounds translate into people's awareness and understanding of the Constitution as well as the CA? How are these differing socio-economic backgrounds feeding into that understanding?
Yeah, so Ritwika, there are two ways I think that feeds into this understanding. One is the class aspect. Yeah, the people who have been able to send their children to school, or who have themselves gone to schools, and who have some sense of, there's some legal regime that runs a country, and so on and so forth. And the other is the class aspect, where people know there is a constitution because of histories that they have heard from communities that become community narratives. This used to happen in our olden times, or my grandfather did this, or my grandfather was that. So this is the class difference. So class, I'm also in a way trying to pick at the urban population versus the rural population. Yeah, and this is where their understanding comes from. While the persons who have been able to have some access to tangible knowledge of it, be it in the form of the book of the Constitution itself, or some commentary, or some just conversations, the others understand it to be a phenomena that had happened and that is going to protect them like forever. Yeah, so this is the kind of understanding and the awareness we have. If we are to take it further, it is important for us at this stage to look at the skills or the tools for them to be able to articulate it in a way to ensure the right. And like we mentioned about the documents, for example, if something becomes as specific as a document in order to prove your citizenship and your rights to have all the other rights, completely rely on them, it is important for us at this stage to tell them, or to make all the bureaucratic procedures accessible and easy for them, so that they have at least a normal life and not an anxious life that they have.
I'm glad actually you spoke about the documentation part of it, because that was going to be my next question, where I think we should also take a moment and delve into the procedural scheme of things. The actual implication of the CA will obviously cannot be grasped without talking about the NRC and the concerns it opens up around documentations and conditions that people will have to produce for buttressing their claim for citizenship. So two key questions on this aspect, and one of this you've already reflected on, is how do concerns around obtaining and accessing documents play out amongst people, specifically in terms of the kind of things you spoke about in terms of anxiety that it sort of builds in people. The other thing, and also because I know your project had a certain component of what is the way forward, what are the possible remedial measures people can take, particularly lawyers can take. So on that aspect, as a follow-up, Afreen, could you tell us about the role the support groups or the lawyer or the legal groups or paralegal groups have been fulfilling or have been playing in building a more informed group of people and assuaging their concerns about the documentation?
So Ritwika, I'll give you just one example about how the documentation procedures play out in the rural areas, especially. The urban areas are a little more comfortable because you go and apply for it, and the agent will take that much time, and he'll get back to you whenever he can. And also because urban areas are typically understood to be more in hand cash. Rich in a way, you could say, not rich, but they have an access to in hand cash is what they are able to pay to the agent as well. But in the rural areas, that's not the case. There would be months and months without any liquid cash around in the house which they could use or give it to the agent. That's one. Say for example about the procedure, if I have to apply for a birth certificate in one random village of any part of the country, maybe it has to go to the tehsil. It's a long procedure. It has to go to the tehsil. It has to go to the SDM. Then it goes to the Nagar Palika, the block development officer. Then it goes to the secretary, then the chief medical officer, then the upper magistrate, and then the secretary and the CMO and the secretary again. And then there is finally a challan. I mean, this I had to write it down because even I couldn't remember it all the time. This is literally how this, yeah, and this is a procedure that people have to and all one procedure, as in one office, they don't do it immediately, right? It sits with that office for like almost a month each. Now with all this welfare schemes about a documentation or a document should be prepared within a month, imagine where this leads people to. And imagine how is that person able to access when that person does not have the money to even maybe pay for their commute to all these offices, because it could be one village and the district is there in like 32 or 50 kilometers away, and so on. And of course, there is then red tapeism, there is bureaucratic arrogance, of course, and there is bribery, the thing that gets brushed under the carpet all the time. So all of these things make it very difficult for common people to access any kind of documentation, let alone a birth certificate or a death certificate. Okay, now with the unclarity about the documentation, especially what we saw in Assam, say there is a list B, list A, and then there is a list B, and then there is a whimsical need of a linked document. What exactly is the linked document? Because in the orders that we have seen, there is the orders have been passed in a way saying there is no linked document produced. Which linked document do you want, and what documents do you need to be linked? There's no clarity. I mean, that is again something to be dealt under the functioning of the foreign tribunals. But if this is how things are playing out in real time, right in front of our eyes, how are we going to deal with something pan-India when the NRIC is rolled out tomorrow with no clarity of what exactly it wants? So it is, I believe it is quite unnecessary, a regime, and an unnecessary harassment of the people.
The problem just gets magnified 10x when we think about this across the country.
Yeah.
Sure. I actually, there's just one strand of thought that I think I left when we were talking about the participants as who you interviewed. Just as an afterthought, that people's concerns centered around the law, the kind of changes it was going to bring about. Did those concerns vary based on the political history or the political experiences of a particular city or town that they were residing in? Did that play a role?
Oh, yes, that certainly did. It was usually in terms of the anxieties it brings to people. So, for example, somebody from Bombay would have a very different narrative of how the CA is going to be played out, as compared to somebody who is outside of Bombay, who has not perhaps seen all those riots and so on, and is younger maybe, who has now not been a witness to anything that brings immediate anxieties to people. So that certainly plays a lot. And when I say Bombay, I'm referring to all the Bombay riots and the experiences that people have of that time. It's similarly in Bhiwandi. The people who have seen the Bhiwandi riots of previous times, they articulate or understand the CA's implications to be different from the people who have not, say the younger lot. So certainly it does play a role. And similarly, when I was talking about people's hope and faith in the constitution and so on, it is people who have peacefully cohabited in a place for the longest of time. So for them, they don't have an immediate memory of a riot other than what they must have heard from other side and nearby places, but not in their immediate memory, and therefore they're able to rely on the constitutional hope and the morality the way they have stuck to it. So yeah, it certainly plays. It certainly has a good role to play there.
That's very interesting to know. I have another question where I feel I might be overstepping a bit, but I'm still going to go ahead and ask this question. You had the opportunity of speaking with lawyers who've represented individuals who've been detained upon being declared foreigners. In the direst of circumstances, when a certain lawyer is trying to get somebody who the person who they're representing out on bail, does the constitution as a document, does that espouse any hope for them, or in that dire situation, does that not mean anything for them?
It certainly does. I think it is the constitutional provisions that keep the lawyers moving, because the foreign tribunals are in utter shambles and whatever their experiences are. And like I referred to all these unpronounced or unexplained orders that the foreign tribunals have been passing. With all the frustration that one has, you ultimately find hope in the constitution. You go to the high courts and you go to the Supreme Court. So I think that is what drives them further. Yeah.
I think I'll again have to say this makes me both happy and sad about the constitution, but we'll leave it at that. So I would be remiss in not asking you about the challenges that were thrown your way after the pandemic began. And so what were the challenges posed by the pandemic in your fieldwork component of your research? More importantly, what were the curveballs that the pandemic sent your way? Because clearly your project involved a fair amount of traveling and a fair amount of talking to people. So how did that play out when you were in the throes of the pandemic?
Yeah, so Ritwika, the proposal was actually drafted during the pandemic, right? That's when we started. So while we were aware of what we might have to keep changing the timelines and so on, what exactly is going to change, that we were unaware of. So that had to be done along with the flow. So the immediate ones, the major changes that have happened is certainly the shift of cities, which I'm absolutely okay now. Which became Balrampur, right, from Bangalore. And the ones where we started was when I would call people, and we were certainly talking about documents and CA and implications of it. People had skeptics. I mean, they were quite a skeptic to speak to me about it, especially because a lot of people did not know who I am. So usually I had to pitch in some kind of reference to bring that trust, and so that people are able to speak to me. That was one. And that kind of indicated the importance of me being present in the fields, and that is why we then took the risk of traveling to all these places. And thankfully, touch wood, I barely escaped the second wave from Delhi, right? So all of these things were the major challenges, certainly. The sensitivity of the topic, even when I was interviewing people personally, you could see the fear in people, because they had to be very sure as to whom they're speaking with and why they're speaking with, and then only they would be able to open up. So that is, yeah, those were the fair share of challenges that came by, but we are good now.
I think one of the reasons why I also asked this question was generally for people who are out in the field researching while the pandemic is, well, of course, still on. I think your whatever you just told us, Afreen, is a good lesson for researchers.
Also, the elections. I was in Assam when the Assam elections were going on. I was in Bengal when the Bengal elections were going on. So it was the same time. So everybody's antennas were already up. Who's this?
Of course.
So yeah.
Right. Considering we just have about 10 odd minutes left, I'll just for the last few questions, I'll just change tack slightly and bring in the role of the judiciary here before we sort of wrap up this discussion. So as we know, a petition challenging the constitutionality of the law is currently pending before the Supreme Court. Afreen, you've been on the ground, you've closely interacted with persons who are most affected by this amendment law. Does the institution of the judiciary, especially the Supreme Court, appear to be the only hope to them, to these people in defending the rights of the Constitution, or how is the role of the judiciary being perceived by people?
As far as the role of judiciary goes, it has one of the most important roles to play if we are to track it right from the Sonowal judgment, if not before that. So that certainly has a big role in all of this. Okay, be it Assam, be it the rest of the country. Now, the question is whether it is perhaps going to be more accessible to people in terms of day-to-day issues of going and proving one's citizenship on the basis of the documents. Is the Supreme Court going to do that? Because the foreign tribunals are certainly failing at it. And because I don't want to delve deeper into the functioning of the tribunal because we have a session tomorrow, right? But a lot of it certainly relies on the judiciary. What we had expected of the judiciary so far was all these matters pending before the Supreme Court. We were expecting something to have happened already, but unfortunately, what we have observed is it has mostly been administrative in its approach, giving directions in some way or the other. And while we are still able to accept that, we are trying and still holding on to the hope that, it is perhaps the judiciary that will still step up and do something about all those petitions. The petitions are not only challenging the constitutionality of the CAA, but so many other aspects of it, and there are multiple petitions regarding it.
Of course.
So let's hope something better happens. In the meantime, like I mentioned, the MHA has requested for more extension because they have not been able to file the notifications and the CAA rules. So that is something yet to be seen. So let's see what plays on further. But we as lawyers certainly can just be available and just do the mitigative parts as much as we can.
Sure. I'll just take one last question, which I've received in the chat box, which talks about a very specific point on ownership of land. So given that a certain sentiment of otherization envelopes certain members of certain communities after the CAA has come into force, after the CAA has been enacted, how does this sentiment play out in conjunction with questions of ownership of land? Has your research thrown any light on this aspect, on the specific question of land ownership and otherization?
So I had not thought about land in any sense of term. I was only looking at the documentation and the implications in multiple other ways, but not land at all. It was very interesting to find it out in one of those conversations when we had the open-ended, post the semi-structured conversations in the open-ended sessions that we used to have, that people have started talking about the Muslims in terms of the other already, that these people will leave and will occupy their lands. And that was the most interesting part. And then I had to take a step back again and think about it and realize that all wars have perhaps happened on the issues of land. It has always been about land, so how could CAA not be? That took me back to a conversation that another lawyer had with me when the 370 was repealed for Kashmir, and it was the moment it is done, I'm going to go buy land in Kashmir. And what is happening in Assam. So somewhere, while it was not my focus, it kind of became a prominent part of the research and prominent outcome in a way, to realize that, this is something that we need to look at. And kind of that, I think that is that in a way that is also one of the major implications of the CAA, because it works as the emboldenment of people to kind of look at people in sense of, or in terms of others, that these are already others. And the ironic part of this is, Ritwika, that this is happening in UP, and the nearest other country is Nepal. So they're not talking about Nepal. So these people will go to Bangladesh and Pakistan. So, which is in a way, yeah, funny, but that's how it is.
That's a rather interesting, if not worrying, sort of thought to part with. I think we're nearing the end of this discussion, and while you've thrown light on several concerning aspects of the law, concerning aspects of how citizens the people who actually stand to get affected by the law are responding to the changes in the citizenship law, and that gives us a lot of food for thought. At the same time, Afreen, I think I will have to say that it's rather heartening to hear from you that people still have hope in the Constitution. They still see this document as a sort of as a power lying above everything else that will, in the end, protect their rights and also protect the values that the framers of the Constitution believe in. So, nonetheless, Afreen, I think that is a rather hopeful thought to part with. Thank you very much. Thanks very much, Afreen, for taking out the time to share your research findings with us. I do believe that your work truly takes the Constitution to the people, and I congratulate you for your stellar work throughout the Samvidhaan year, as well as your considered efforts to make access to justice a real and an achievable goal. So brilliant work there, Afreen. Thank you to all the members of the audience also for joining this discussion. I would like to request all of you to please stay online on this link and stay tuned for the next session in the open house, which will be a panel discussion on making the Constitution and its vocabulary more relevant to the lives of everyday Indians. We will have Justice Deepak Gupta, Mander, and Meira Kumar, and the discussion will be moderated by Alok, Prasanna Kumar. Thanks very much, everyone. Thanks a lot, Afreen.
Thank you so much, Ritwika, for having me. Thank you so much.
Okay, take care. Thank you. Stay safe.
Maitri, can I begin?
Yeah, Alok, go ahead.
Okay. Thank you, everyone. Thank you for joining us today. And welcome to the panel discussion that we had, that Ritwika just mentioned. Just one correction, of course, we are being joined by Justice Gita Mittal, not Justice Deepak Gupta. But as Ritwika mentioned, we do have a very eminent panel who have joined us today. We have Ms. Meira Kumar, who was the former Speaker of the Lok Sabha, apart from also being a minister herself and an MP. We also have Mr. Mander, who's the director of the Center for Equity Studies, apart from being part of many civil society initiatives, which have tried in many different ways to take the Constitution to the public, to address issues of communalism and foster a spirit of equality and fraternity. And we also have Justice Gita Mittal, who was former Chief Justice of Jammu and Kashmir High Court, prior to which he was also the acting Chief Justice of the Delhi High Court, and has been a judge of the Delhi High Court for a very long period of time, and has since been involved in many initiatives. And I've only given a very brief description of them because I do believe that the members on the panel are all pretty eminent personalities who most of you would know about. And what I hope to do over the course of the next 1 hour is to get them to weigh in on an issue which those of you who have already tuned in would have heard Afreen and Ritwika speak about, which is how do we take the vocabulary of the Constitution? How do we make it relevant to the lives of people on a day-to-day basis? Before we begin our discussion, we have a very short presentation by my colleagues Apurva and Vidhi about a new initiative that Vidhi has just rolled out. And I'm very pleased to bring to you our database on pending Constitution bench judgments in the Supreme Court of India. And I will let Apurva and Vidhi take 5 minutes to tell you why we did this and what we have for on our plates, or what we have on our website, at the end of which I will begin with the discussion. Apurva, Vidhi, over to you.
Thanks, Alok, for having us here and for launching our portal in this really eminent panel. So to just give you a history of why we started the Constitution Bench project, and for anyone who's working on judicial reforms, data accessibility has always been an issue. And I think everyone's really been spearheading the want to increase access to this data. So as a part of Jaldi's initiative, we started the Jaldi data portal, which puts out some amount of data on issues that either relate to diversity. We have some on judicial infrastructure. We have a portal that puts out formats for filing RTI applications to high courts. We even have data on budgeting. This time we are having this new portal that we're releasing is on the Constitution Bench Tracker. So what does this portal really do is, one would think that information on all the cases that are pending before the Constitution Bench would be, publicly already available. But unfortunately, that's not really the case. We have a lot of historical data on, the big judgments that have been given. They've really changed the way that we understand Indian jurisprudence. We also have news articles, etc., on cases that are now being heard in court. There's a lot of news coverage, there are opinion pieces, but cases that have been pending for a while and not really being heard by court right now, there's not a lot of conversation around that issue. What we're trying to do with this portal is highlight that section of cases. So in order to get information on this, we went to the custodian of Supreme Court data, which is the Supreme Court website, and we tried to find the number of simple question of trying to find the number of Constitution Bench cases that are pending. It turns out it's actually a really difficult question to answer, because the Supreme Court in its one of its tabs has consolidated data set, consolidated number of pending cases, in which a small component is also number of Constitution Bench cases. But this is not an itemized list, so one can't really discern what are the list of cases that are pending. So we went to the terminal cause list, which does provide a list of cases that are pending. Now, since these are, say, one would think around 500 odd cases, so one would assume that the data sets would automatically superimpose and be completely the same, right? But unfortunately, that wasn't the case either. So we had to file an RTI application with the Supreme Court in order to know what were the cases that were pending before it. And the response that we got is now being used as the primary data set that we've worked on. And then we've had to amend it and change it to also make it more relevant, and also, customize it based on what we saw from the orders, etc. Tag matters and a lot of other specific things. But what we did with the data set and the big question of how many cases are actually pending, I'll let Apurva explain those. But thank you for having us here, and we look forward to maybe people using this data set, whether it's law students, whether it's journalists, whether it's lawyers who are primarily just seeking to have a bird's eye view on what's happening in these pending matters. So thanks.
Thank you, Vidhi. Good evening, everyone. So continuing from where Vidhi left off, I come to what we found through this gigantic exercise. The first thing and the most startling revelation was that currently there are no active benches hearing these matters. That means even though benches were constituted, judges who were part of those benches have retired. So out of all the matters that are pending before constitution benches, there's not a single active bench listening to them. The other thing that we found is that some of these cases have been pending for so long, for decades on end, that the questions that were involved in those cases have become infructuous. So even if the Supreme Court does decide on them, it doesn't really make much of a difference. Coming to the numbers, what we found was there were 35 main matters. However, when you add the connected matters to this, the number exponentially rises to 587 cases. Now, majority of these cases are before 5-judge bench cases, with only 5 cases before 7-judge benches and 9-judge benches. Since Vidhi alluded to the importance of this portal for law students, Vidhi will be organizing a blog writing competition for law students in the coming months. We have a very short explainer video to walk you through our portal. Maitri, could you please play the video?
Introducing the Constitution Bench Pendency project, an attempt by the Jaldi initiative at Vidhi to summarize all the cases pending before Constitution benches of the Supreme Court. The project is hosted on the Jaldi portal on Vidhi's website, which can be accessed from the Jaldi portal homepage. Once you arrive at the landing page for the project, you can learn more about the project by clicking on the About tab. This portal records 3 categories of pending Constitution bench cases, which are 5-judge, 7-judge, and 9-judge cases. Clicking on any of these tabs will take you to the list of all pending cases in that category. As you can see, there are 5 7-judge bench cases pending. The description below the cause title provides a gist of the major issue pending adjudication in that specific case. Click on each case to read a summary. The first part is a timeline of events. Where available, corresponding court orders have been hyperlinked with the date. Navigate the timeline by using this arrow. The various parts of a case summary are available as tabs on the top right. For this case, clicking on the bench composition shows the bench status as not constituted. It also shows the judges before whom the case was last listed. Click on a judge's name to see their profile. After the bench composition, we come to the case summary section. This section contains the background, questions of law, laws under challenge, arguments made by the appellants and respondents, the court's reasoning for referring the case to a constitution bench, and the precedents under conflict in that particular case. Since the summaries are for the main matters, clicking on the Tagged Matters tab shows the connected matters, with the last column showing how long a particular tagged matter has been pending for. Finally, the further reading section provides links to various other sources pertaining to that case. Clicking on the back button will take you back to the list of cases.
Thank you, Apurva. Thank you, Vaidehi. I think that's a very exciting portal, and for those of you who are interested, my colleague Maitreyi will be shortly sharing a link to the portal in the chat, so all of you can check it out. But I would, of course, advise you to wait for our panel to take place, because we're going to have a fascinating discussion. And so I think we will start with the discussion. And perhaps, ma'am, I would like to start with you, Ms. Meira Kumar. You have been someone who has, of course, been in the IFS and then been an MP yourself. You have been a speaker and you have been a minister for social justice. And it's perhaps part of your job description almost that you interact with a very, very wide cross section of people in the country in your capacity as one of as an MP or as a speaker. And what perhaps interests me and what perhaps our audience would also be interested was, how did you sort of hear from the people? What did they find relevant about the Constitution in their lives? Did they as citizens, did they as the voters, did they as people you would interact with, did they make their claims using the vocabulary of the Constitution? Or if not, what did you feel was the gap in the way in which they articulated these values to you?
Thank you so much. My greetings to everybody, and thank you for inviting me. It's a very interesting question and quite a vast scope. It's a big canvas. Now, so far as the vocabulary of the Constitution is concerned, I should make it clear that it is so straightforward and so simple that it is even taught in the schools, and school children are able to understand it without any kind of interpretation. So I would say that the vocabulary of the Constitution, one must remember that when the Constitution was being framed, the partition was going on. And there was this horror and trauma of a blood-soaked partition. In the middle of that, our Constitution makers, the founding fathers, were able to produce something so classic and something so relevant to the people of this vast country. That's not just a vast country, but also complex and complicated. Yes. And I would say, so far as the vocabulary of the Constitution is concerned, it is the spirit of the freedom movement.
All right.
The freedom movement was unique and so large in its magnitude that the world has not seen something as large as that ever. Yeah. And it was so large because not only the upper echelons of the society joined it, they were not very large in number, but because millions and millions of the marginalized the weak, the poor, the Dalits, the Adivasis, and the women, mind you, the women joined it. And they fought for it. They were ready to make supreme sacrifice, lay down their lives. And I just wonder why. Because over the centuries, this section of the society, which is called the disinherited or the broken people, have got nothing out of this country except humiliation, inhuman treatment, and insults. So why were they fighting for the freedom of this country? That's a big question. And they were fighting, in my view, because they saw a glimmer of hope that out of this struggle, the new India that will be born will be the land of their dreams. But this constitution, the sacred document, is actually the vocabulary of those dreams.
I think that's a fantastic point, ma'am. I think that's a great starting point for this discussion, which is that the vocabulary of the Constitution is these dreams and these hopes put into words, put into effect. I'd now like to bring in Mr. Harsh Mander, and Harsh is somebody who has been involved with a number of initiatives. And I think just to take off from what Ms. Meira Kumar said, we have seen in the recent past people using the text of the Constitution. The one recent movement was the Pathalgadi movement in Jharkhand, where the Adivasis used the provisions of the 5th schedule to make their claims against a law that they felt was oppressive. And we've also seen that in the protests against the Citizenship Amendment Act, we have seen that protesters spontaneously refer to the preamble as a way of making their claims. Perhaps you could also sort of talk to us a little bit about how you have seen people express the vocabulary of the Constitution and what is it meant to them?
Thank you, Alok. I also love the way Dr. Meira Kumar spoke about the Constitution, the vocabulary of the dreams of our dispossessed people. What is a Constitution? I would say it is a dream, it's a vision, it's a set of promises, a compendium of guarantees, a storehouse of aspirations. It is a collective imagination of the destination which a country pledges to reach. And it is also a solemn articulation of the values that a country will hold close to its soul in its journey in the decades and centuries that lie ahead. It is a very precious, it's a very sacred document. Many of us, especially people who come from educated backgrounds, from the middle class and so on, assume that ordinary people don't understand what the Constitution really stands for. We have to stand as guardians of the Constitution. We also have to explain what the Constitution means to ordinary working class people. I think that the protests against the citizenship amendments in winter of 2019 for 100 days. I was privileged to actually be in far corners of the country almost every one of those 100 days. Speaking to huge audiences of 1 lakh people and more, sometimes to smaller Shaheen Bagh kind of gatherings of working class women in many parts of the country. And what was, there were many things really exciting about that moment. It was the largest, it is the largest movement, non-violent resistance movement that the country has seen since the freedom struggle. And it embodied many of the very core values of the freedom struggle itself, which Dr. Meira Kumar spoke about. And I think that history will remember this movement for many things, but it was a movement, and I don't know of many examples anywhere in the world where the Constitution itself became the icon of the protest. So it was, we, the people of India, had given ourselves a constitution which we, the people of India, felt was under threat. And we, the people of India, came together to defend and uphold the morality of that constitution. It was a historic moment. People say, that movement, has it failed? I think the very fact that the people of India demonstrated across this country how much they value and stand for this constitution. And it was a movement where spontaneously it was, from that first night after the police entered the Jamia university, people gathered in large numbers in the middle of the night. And I found that there were two icons that they raised. One was of Mahatma Gandhi and his idea of an inclusive country for people of every faith and caste and identity. And the other was the picture of Dr. Ambedkar as the symbol of radical equality and the constitution itself. I mean, we were really privileged that a person of his intellectual and moral caliber led the writing of our constitution. Young people of India actually put this up. It spread to universities. Hindus and Muslims, students of every identity came together. But it was in the working class gatherings that I realized how much people understand the constitution and how much it means to them. And, I still get goosebumps when I recall every gathering used to end with usually a young girl would come and she would read the preamble of the constitution line by line, and the entire gathering would repeat it line by line with her. And it was a very emotional movement for all of us, because when we read "We the People of India," I really saw we the people of India give to ourselves a constitution, and that was being actually demonstrated in every corner of the country, big cities, small towns, villages, and far corners. I don't want to say too much more, but in these smaller gatherings, especially with working class women, many of them Muslim women, in these smaller gatherings, I decided to have a conversation about the constitution. I said, we're upholding the constitution. What does the constitution mean to you? And it's something that, again, I'll always remember how much I think they captured the spirit of the constitution. They won't tell you section so-and-so, article so-and-so, and so on and so forth. But they understood that this constitution, above all, what they repeatedly said was, this is a constitution that says all of us are equal. People of different religion, different caste, different gender. We are all equal in this country. We have equal rights. We need to be equally respected and protected by our government. We have the freedom to follow our religion. We have the freedom to disagree with government. These things I heard from working class people, and largely in many of these gatherings, women. And after this, no one can say the constitution is something that is imposed on the people. I think the people of the ordinary working class people of India have defended the constitution more than its educated elite. And we must respect them and carry forward this duty of defending the constitution.
Thank you, Harsh, for that very valuable input in terms of how people have internalized these ideas themselves, even if they may not specifically say with reference to this article and that. I now want to ask Justice Gita Mittal, following on from these two in particular interventions. We as lawyers, we are trained to see the constitution in a particular way, and I have had non-lawyers reach out to me saying, listen, I know this constitution, the constitution is a wonderful document. It has all the values that Dr. Meira, Kumar and Harsh just mentioned. But when I sat down to read it, I couldn't make any sense of it. And they ask us lawyers, how do I make sense of this document? So in a sense, how do you think lawyers can sort of contribute to this, building this vocabulary of this constitution? That the ideas are there, maybe a basic language is there, but offering that nuance, offering that complexity, how do you think we can sort of communicate this to the public in general? Ma'am, you're muted. Ma'am, you have to unmute.
Thank you very much for giving me this opportunity of being on this panel. First of all, let me tell you how enlightening I always find to be part of panels like this and to hear people like Miss Meira Kumar and Mander, who has been a litigant in my court in a matter challenging the big, which was pending for years and years, And, as judges, well, I was the lawyer for 23 years and a judge for 16 years. But those 16 years actually sanitize you or take you away from society. And it is very heartening to be reliving, having retired and reliving the spirit and soul of the Constitution. But, to answer your question very shortly, you would tell lawyers who ask this question, please read Nariman, read Sirvai, read Palkiwala, and you will get the answers to your words. Even more important is to read some of the judgments which the Supreme Court has handed out. But, very briefly, firstly, just coming to the vocabulary of the Constitution and the way we have read into the Constitution. For me, it's very heartening to know that the public is responding and is actually reading the preamble and rereading it, and the responsive audiences that Harsh has just referred to is extremely heartening. It shows such a sensitized and a conscious society and shows there's great hope for the future of this country. But there is a constant debate. You are very well aware of it as a legal expert, and the conflict. We all know, as Meiraji has said, that the Constitution has evolved, has the Constituent Assembly, as we are aware of, was most heterogeneous. The people who constituted the Constituent Assembly were so inclusive. It didn't matter which political party you came from, what religion you came from what caste you were, which region of the country, gender was represented. And it was such a heterogeneous body which brought forth this beautiful document. Now, the Constitution has expressed itself through explicit words. It uses expression as when it's giving rights in Part 3 as right to life, freedom of expression, very definite words. Now, where do these words came from? To borrow the words of Ms. Meira Kumar, they came from the milieu of the citizens, of the people who formed this country. They came from the social background of the framers of the Constitution. And if we remember the debates which took place at that time, they were so relevant. Now, this formed the vocabulary of the Constitution. But words or vocabulary or language is not static, just as social values and norms are, social notions are not static, and they evolve. So, if you look at, I'll give you a very, very, very well-known example of the American Constitution. The Constitutional Congress, which was packed into that small hall in Philadelphia in late 1700s, writing out the Constitution of the USA, came up for words which were in currency in those times. And then a battle was, but we see a battle being fought in jurisprudence on the words which the American Constitution has. When the founders said, all men are created equal. We've heard these perpetual debates in our legal worlds as to did they include women in the men, or if they did, then did it include black men and black women as well? Now you are also aware of what Justice Kalia, the late Justice Kalia, led as an originalist, that you have to stick to the exact text of the Constitution and you cannot vary or deviate. And it must be interpreted on the lines in which the founders did. So, textualism was the foundation on which interpretation of constitutions read. Now, the Second Amendment, what I'm talking about, the evolution of the society and why we must contextualize the words in the Constitution, and which lawyers especially must do so today, is very well borne out by what has happened to the Second Amendment to the US Constitution, which was drafted on the 15th, came into existence on 15th of December, 1791. This was what it said: a well-regulated militia being necessary to the security of a free state, the right of the people to keep arms shall not be infringed. Now, this came into existence in 1791. America got its independence in 1778. So there must have been a lot of tensions and a lot of violence being faced by the community. And this amendment came into the American Constitution in those times, keeping in view the social context, where the American society was placed. But what are we seeing today? You see children of 10 years branding arms. You see violence in schools. You're seeing churches, people in church congregations being attacked. And any attempt to modify the constitution is really resisted by people who quote this as their constitutional right. But the society has evolved. There is no need for having militia and no need to carry arms around in the community and society. And the constitution has to keep faith, keep times. But where the amendments have not happened, but it is for the courts which have, in India, the Supreme Court has read in repeatedly, as to how the constitution is a living, organic document. The dynamism has to be as an integral part of its interpretation. Justice Chandrachud has read part 20, the Article 368, the power of amendment in this case, Puttaswamy, the
Puttaswamy judgment, yes.
Judgment, to say that by itself shows that the constitution makers intended that the constitution be an evolving document. Now you look at another instance that I would like to say is that look at the post-war constitutions. You see India, Burma, Lanka, Nepal. Their focus was on rights, but they were a product of times. You see the Indian constitution. It still uses sex. In Article 15 and several other provisions, there is no reference to gender.
Yeah.
And the Supreme Court, by constitutional interpretation, has read in sexual orientation into these constitutional provisions. Whereas now you see the South African constitution, which has come into existence in 2007, it explicitly mentions sexual orientation. So we have had to have a very, very long haul. This sexual orientation was of extreme importance when you dealt with the rights of the transgenders in the Nalsa judgment, when you dealt with the constitutionality of homosexuality. Now, also the long debates over the exact meaning of procedure prescribed by law, due process. The constitution makers explicitly did not use this expression explicitly in the constitution. They preferred to use procedure prescribed by law, and look at where it has taken us. So this is, and the courts have had to interpret and evolve, and it was the liberalism and the foresightedness of the judges who worked the constitution that all this has come in. We've had judgments say that such kind of dynamism is essential to ensure democracy. It is necessary that the constitution doesn't. This flexibility is necessary, that the constitution rights don't get fossilized or atrophied. And you see there there's no time to get into all the beautiful enunciation of the jurisprudence on this. But there is, what is specifically said is, and this is for the lawyers and the courts who are working the constitution, that the provisions of the constitutions must be read in the light of contemporary circumstances and values, and also in such a way that circumstances and values of the present generation are given expression in its provisions. Yeah. Constitutional interpretation is as much a process of creation as one of discovery. Such interpretation has to be guided by the letter, spirit, and purpose of the language employed, and also consciously by the constitutional silences and abeyances. And there must be a spirit of discovery, which has a connection with the theory of constitutional implication. But, I would like to share with you one personal experience with judges. You referred to lawyers. Professor Mohan Gopal was a former director of the National Judicial Academy, and he used to have a very, very important session in the training of trial court judges, which was the relevance of the Constitution in the working of the trial court lawyers, judges.
Yeah.
And I put this question to some district judges when I was training them on the on the working of the constitution, on the constitution law in a district court training session. And none of the judges could say where they employed the constitutional vision or the constitutional values in their daily work, So I put it more specifically, where would you work the constitutional rights in your daily work in a criminal court, And they were not even able to home in on the principles laid down by Sunil Batra, the constitutional judgment, rights of prisoners to legal aid, to health, to the facilities of, no handcuffing, to ensuring that they had a competent lawyer, what was happening to them in the lockup. And they were not even able to visualize where they would work these rights. In the courtroom, where was the prisoner before a judge? He comes, he's brought before the judge when he's arraigned for remand, for trial, for several other reasons, or when he's in court custody, when he's in the lockup, where he's brought in from the prison, waiting to be called up for his case. So it's extremely important that we are conscious of the values of the Constitution, and judges and lawyers have a very onerous duty. They are the first position, first place where a person will go where the right is infringed or violated. And in coming back in this, I will link it to what the project that you have just told us about, Apurva and her colleague Vidhi just spoke about this. I would request you to look at what is the status of the cases, since COVID-19 happened. Court after court is adjourning cases en bloc. We are not even looking at the cases which are listed. I don't see where COVID-19 here, bars a court from looking at cases which are listed on the diary. They are going and saying that they will only look at urgent matters, which means cases which are filed and are new, and the old cases are not even being looked at. So perhaps I would request you, Alok, to tell you
absolutely
this question, because it has a very important right. Access to justice has been interpreted as a basic fundamental right, integral part of right to life. And we have very badly impacted that.
Yeah, absolutely. And I want to bring Ms. Meira Kumar on that particular note, because you started off on this idea that our constitution, the vocabulary of the constitution, is a reflection of the aspirations and the hopes of the dispossessed and the marginalized peoples of India. It has been 75 years since independence, much longer since the independence movement started. How have these aspirations and hopes changed? And because keeping in mind how you have had a chance to interact with wide cross-section of people, and I always tell this to everyone, that the average LMP in this country is probably the most hardworking, the most difficult profession, because how many demands are made on their time by their constituents, how many requests are made of them. And in terms of how people have approached you and how you've sort of seen people framing their requests for you, how do they concretize their hopes and aspirations from the constitution to what they expect from not just say one MP, but from the political system? That's something that I'd hope that you could sort of tell us.
Thank you so much. Let me first pay my respect and also acknowledge the indebtedness that I have towards all the 299 members of the Constituent Assembly. No one is more and no one is less. And what they have done is, after examining every word and every clause of the draft constitution, thoroughly discussing it, threadbare, and then finalizing the constitution. So I would, say that no one is greater and no one is less, so far as the members of the Constituent Assembly are concerned.
Yes.
Now, the vocabulary of the Constitution. Let's come to the preamble, because Dr. Mander said that preamble was being read again and again. And by the way, this place was very close to where I live, Shaheen Bagh. Now, preamble. Preamble has some very categorical words, and they are written in capital letters. But don't forget that they are written in capital, bold letters. And what is the message of the preamble? Abolish the caste system. By saying that democratic, you cannot have democracy. Democracy is based on equality. Caste system is based on hierarchy. They cannot coexist. Then you cannot have equality and caste system, again on the same basis. And then you cannot have justice and caste system, because the system is totally unjust. There's this epic poem of Coleridge, Ancient Mariner, and they say, water, water everywhere, not a drop to drink. And this country is a land of plenty. But there's so much of want and hunger and poverty. Because the ancient mariner had committed a sin. And he had an albatross around his neck. Yes. We have an albatross. We have the caste system around us. Yeah. So unless we overcome, and unfortunately, I'm saying, even after so many years, we have not even been able to overcome. Because apart from what is there in Article 15.1, 15.4, then we had the Untouchability Offences Act of 1955, which was again amended in 1976 as protection of civil rights. Then there was this 1989, we had this Act for Atrocities, Prevention of Atrocities Against SC and ST, which was amended in 2015 and 2018. And I'm very sorry. I thought this act would be scrapped. I thought all these three acts would be scrapped. But I'm sorry that the situation in the country was such that these acts had to be made more stringent. So obviously, this very unfair, unjust system has not gone. Unless it goes, how do you expect the country to really progress? Be modern. You have to be modern, not in your dress, not in your speech, not in your behavior, in your thoughts, in your mind. And that is very important. This is what the vocabulary of the Constitution is. The other thing is the vocabulary of the Constitution is secular. Yeah. Justice Mittal has mentioned, the Honorable Mander has mentioned that secularism. Now, earlier it was not there. It was introduced by 42nd Amendment, 1976. But underlying subterranean current and very strong current throughout the Constitution is that we are a secular state. We are a secular state. And this is what CAA has done. That it has attacked this secular nature of our country. Secular. We are the only country in the world. Please correct me if I'm wrong, but we are the only country in the world which has 8 major religions of the world. Maybe Judaism is now too much minority, but even then we have it. We have 8 major religions existing here for centuries, and we can't be impervious to them. I just can't say that I'm a Hindu and I have no influence of Islam on me. I have no influence of Christianity on me. I have no influence of Buddhism on me. I have no influence of Jainism on me, Judaism, Zoroastrianism. I mean, everything is inside me. And that is the beauty. Yeah. That is the legacy of this country. And this is what is the vocabulary of the Constitution. This is what we have to preserve. Yeah. And now you're talking about what the MPs do. Yes, MPs have very tough time because every MP has minimum of 20 to 23 lakh, even now even more.
Yeah, it is.
People in the constituency. There are so many demands. Most of the time, they're conflicting demands. Sometimes we want a road. Now the other group will say we should have road going in this direction, crossing through these villages. Another group will say no, the road should be going in another direction. Now you can give one road. So there's a clash. There's a clash over so many things, which is not unjustified. It is human nature. Everybody wants something, you see, and it may be in conflict with what the other person's interest is. So the representative has to cater to all that.
Yes.
And then we have LSTV. Earlier we didn't have a TV. Now we have a TV in Lok Sabha and Rajya Sabha, which shows what the MPs are doing. Sometimes they jump in the well. I used to call them in my office and I said, why are you jumping in the well? Why are you shouting so much? So what do we do? If we don't jump in the well, the people in my constituency will say, well, you were not protesting enough. You were not raising our demands in the house.
Yeah.
So you see, a lot of people have been very critical members of parliament, but they should also understand that pressure of more than 20 lakh people on one person, and he has to all the time work on it. When when I came, I said, as a speaker, what do I do? How do I take that? Madam said just now, how do you take it to the people? Now, people already know. It's not that they don't know. It will be very arrogant of me to think that only I know and the other person doesn't know. He also knows. Maybe he's not able to quote all the articles, but he knows the spirit and the vocabulary of the Constitution. So I said, okay, let me have programs where I would call school children and tell them about every month. I used to have a program about a speaker. So I used to tell small children, very simple words, what the Constitution is and how it works for us, how it protects us. It protects us. The Constitution protects us. You see, in 1988, when I was member of parliament, I became member of parliament for the first time from Bijnor. There was this very, very, very disgraceful thing was going on in the country that people don't want girls. And they used to have this amniocentesis test, which could indicate the gender of the fetus. So they would go for this test. And when they found out that it was a female fetus, they would have it aborted. So I brought this private member bill to ban this. Well, after some time, the government brought it was banned. So what I'm trying to say is that the Constitution protects you even before you are born.
Yeah.
You see, the Constitution has this legislation where the test of the gender of the fetus is banned. So you are protected right from before you are born. Once you're born, then you have the vaccination, then you have the inoculations. India, we should be feeling proud of it that we have the highest number of polio vaccines given in our country. It is a great success story. And then we have this right to education, free education. It is there also in our directive principle. We have also made a law. Luckily, fortunately for me, I was presiding at that time. I was the speaker. Then we have midday meal, the biggest program in the world to feed children in government schools. You see, so all this the Constitution is doing, reaching out to
Yes.
people, reaching out to different kind. When you, even before you're born, when you are born, when you are a child, and then there is this so many laws against child labor, protecting the child. Then you have Mandrika, so that even the poorest of the poor, when there is no cultivation, agriculture is not really offering them jobs,
so
they can earn, they can have some subsistence.
And ma'am, on that note, I actually want to bring in Mr. Harsh Mander, because you pointed out something very important there in the course of your discussion. And this is a question that I've been wanted to ask Mr. Harsh Mander, and actually it's been better framed by a colleague of mine, Rahul Bajaj, who has put it in the comments. And I'd urge our participants to please put your questions in the question and answers, because enough of me sort of just asking the questions. I'll sort of, I'm sure you all of you can frame it better. What Ms. Meira Kumar actually sort of described is how the Constitution puts certain onuses on the state to do things for the people, to ensure that certain rights and entitlements of theirs are taken care of. But Rahul has a slightly different question. What role do you think the Constitution and its vocabulary have in disciplining the conduct of private actors? How do we ensure that constitutional values apply in relationships between citizens and not just say between citizens and state? So we've seen what the Constitution sort of says, and in that context, how do we see this? And especially since we've been involved with Karwan-e-Mohabbat and more of other initiatives, perhaps you would like to sort of tell us a little bit about that.
Thank you. I think Rahul asked a very important question. Just before that, just a couple of things to my co-panelists. One, now that Justice Gita Mittal has retired, I can speak more freely. I have, the judgment that she has given on, on begging. I basically had said that made basically reference to the Constitution and constitutional morality in a sense. And it's a beautiful judgment because it's just 25 pages. It makes a very, very clear, how the Constitution, it's an example actually of the Constitution coming to the aid of really the most disadvantaged. A person who's destitute on the streets actually was rescued by this judgment where Justice Mittal saw her situation in the light of the Constitution. So I just wanted to express my appreciation. And on the vocabulary, I just wanted to add something. In these conversations, I realized that, you speak in Hindustani, just those 4 words: justice, liberty, equality, fraternity. Justice, you say insaf.
Right.
Nyaya. Sabke liye insaf aur nyaya barabar. Then freedom, liberty is azadi.
Yeah.
Everybody understands azadi. And kin cheezon ke liye azadi, you can talk about that. Equality, barabari. And fraternity, and I wanted to come to the answer to my question, to the question that Rahul has asked, is in the idea of fraternity. Now, fraternity in English actually is a slightly problematic word because it literally means brotherhood. And so once again, what about sisterhood?
Yeah.
But the Hindi word in our Constitution is actually such a beautiful word. It's bandhuta. It comes from the Sanskrit that hum ek dusre se bandhe hue hain. We all, our destinies are tied to each other. And that is really my answer to Rahul. When he spoke about fraternity, Dr. Ambedkar, he said something very, very wonderful. He said many wonderful things, but this I really like, because he said that justice, liberty, equality can happen without fraternity, but then it has to be enforced by the power of the state. But if there's fraternity, then these become the natural order of things. Then you don't have, if there's fraternity in society, then you recognize equality. You want justice for all, and you respect each other's freedoms. So I think that the greatest obligation of the Constitution is really in our relationships with each other. Dr. Meira Kumar spoke about the banning of untouchability, which is sort of unique to our Constitution. Untouchability is something that is in our relationship with each other. Gender injustice is in our relation with each other. We might need the state to enforce some of these equalities and provisions, as Dr. Ambedkar said, but in the end, it is an obligation on how we treat each other. And I think we are living through times when a simple basic freedom like the freedom of worship is under so much cloud. I must respect this country was founded on the idea that it does not matter which God you worship or if you worship no God. It doesn't matter what your caste, what your gender, what your wealth, what your language. You are an equal citizen in every respect. And I think that this is again something that we have to respect with each other. Just to give an example, when crowds come out in the city, actually, Gurugram is the city with the highest per capita income in the country. And we find people coming out in large numbers to prevent Muslim people on Friday afternoon to say their prayers. The state needs to act, but in the end, what is it that the rich, middle class, well-to-do people of Gurgaon, you have a city which has grown very fast. The migrants have come in very large numbers. They contribute to the wealth, but there are only 2 mosques. They will need a place to pray. The Constitution has given a guarantee for that place. Why is it so important for you to block them? I saw this picture, just as an illustration, of very nice looking young boys. And they were posing for a picture. Why? Because they want to play cricket on the space, on the ground where namaz is said. And they think they're doing some very great thing by blocking their brothers and sisters from their most fundamental right to pray. So I do think the Constitution, in the end, places, especially with the idea of fraternity, the idea of the banning of caste, the idea of secularism, ultimately places duties on and gender equality. It places duties on citizens in how they relate to each other. हम एक दूसरे से बंधे हुए हैं. आपके ऊपर जो नाइंसाफी है, मैं अपने ऊपर महसूस करूं. तो मैं जब पहलू खान के पीठ पे चाबुक लगे, मेरे पीठ में दर्द उठे. तब that is with the Constitution. जब एक दलित बच्ची का गैंग रेप होता है, मुझे वो दर्द हो जैसे मेरे अपनी बेटी का गैंग रेप हुआ है. ये संविधान ने वादा किया कि ये एक समाज ऐसा होगा जिसमें बंधुता होगी. And I think that's primarily a responsibility of citizens to each other.
Yeah, thank you so much for that, Harsh. And I think the way the words that we mean, they get a very different color, get a different meaning, they get a very different feeling. Let me put it that way. When you sort of translate it into Hindustani, in fact, I was reading a very interesting book actually on Ambedkar's preamble by Akash Singh Rathore, where he offers another word which in fact expands the scope of bandhuta also. And that word is actually metta or maitri, which comes from Sanskrit, metta, which comes from Pali. And that has to do with the Buddhist conception of loving kindness. We don't just see each other as, okay, we are stuck, we should live together, but you show that loving kindness to someone else. And that is what makes for, and that also comes not just between individuals, but also people who are in the government and in the state. And actually, Dr. Ambedkar, even his thoughts in the Constituent Assembly, he wrote much later on what he actually had thought of, and he developed his thoughts even more. And that's a fascinating discussion. I don't want to just go into that one direction, but just as Mittal, actually, there's one question which has also come in, which I think it'd be very interesting, because you made this point about the training of judicial officers when you went and spoke to them. And my colleague Lalit Panda has sort of articulated one particular point that had occurred to me, which is that, is it enough to just say that these are the broad principles that you as judicial officers should apply when you sort of this is a constitutional principles you should think about, but should we also find ways to particularize some of this? Because to me, I've started to believe that a lot of our criminal procedure code itself is an encapsulation of so many principles of the Constitution. And maybe we should be telling our trial court judges that you are also constitutional court judges. It's not just Supreme Court, High Court. So maybe if just on that point, if you could sort of talk a little bit.
I learned about this. We are very hierarchical in our system, but I saw that even though hierarchy of courts in terms of jurisdiction is maintained all over the world, whether it be United States, whether it be Singapore, whether it be New Zealand, we all form hierarchy, but we are kind of feudal in the way we work, And my first message to every judge has been that be whatever level judge you may be a munsif, you may be a civil judge, you may be a magistrate, you may be a district judge, you may be a high court judge, Each one of you is as important as a judge in any other position. I would even put Supreme Court judges, because what a magistrate can do, the sessions can't do. What a sessions can do, the High Court can't do, And each one of these jurisdictions is very important. So the first and foremost thing that we must do is empower these judges to have respect in their positions and the work that they're doing. That is extremely important. The second thing, linkage is not only in the criminal law. Alok, I have gone into the basics of, say, the building bylaws. If you are required to construct your property and leave a 10 feet setback in the front and a 6 feet setback in the back, there is a reason for that. It relates to the right to access or to light and ventilation of your neighbor. So, you are required to make a sacrifice by the building bylaw. Where does this sacrifice come from? It flows directly from the right to life of your neighbor, and your duty the duties which the Constitution imposes on you. I'm giving you a very, very loose example. Not cutting trees. There's a whole law in place. There's a tree officer whose permission you're supposed to take before you cut a tree. Why, you may wonder why do I have to take permission? But then again, it stems from every citizen's right to a clean environment, a pollution-free environment, a healthy environment. Now, Justice Meira Kumar, Ms. Meira Kumar has referred to, the right to education. It initially was recognized by the Supreme Court. It was wonderful that the state recognized it and it brought in Article 21, capital A, into the Constitution. But to work it, we needed the law. And the legislature has worked and given us the law. So, if you connect what the trial court is doing, and we teach these judges that this is the work, this is where the statute comes from. This is where the basic foundation, the fundamentals of every law, actually, the law flows from the Constitution. If we teach these and the values to the trial court judges, I'm sure we'll have a very sensitized judiciary. And we need to do it on a war footing.
Yeah, absolutely, ma'am. I completely agree with you. And we have almost run out of time, but I'll close this fascinating discussion that we've had, this deeply enriching discussion that we've had. I'll close with one small short question to Ms. Meira Kumar, and then we will end this session. Ma'am, you mentioned that you had made in your personal capacity efforts to educate school children about the Constitution. Justice Gita Mittal has just mentioned the efforts that she has made in the context, and of course, Mr. Mander has also mentioned how they've gone about sort of talking about the Constitution. How do we make this systematic? If I had to sort of come to you with a plan to say what should all of us do, and I don't just mean the government, how would you give a role to someone to say, this is how you popularize the Constitution and its vocabulary among people? What would be your one idea to get this done?
Effort for attitudinal change.
Right.
The Constitution is there, it is all pervasive, all embracing, it is fighting for equality. But if your mind is not ready to accept it, then it remain just dead letters.
Yes.
The Constitution is too precious to us. There's so many countries, even today, they are struggling to have a constitution. They don't have a constitution. There's so many countries who don't have a written constitution. We are very fortunate we have a constitution and it touches every aspect of our lives. So something so precious. We should ready ourselves, we should prepare ourselves to be able to value it. We must have attitudinal change. Without attitudinal change, you may have as many laws as you like. You see, judiciary is a pillar of our state. The legislature is a pillar. Executive is a pillar. Social, civil society also. Press is a pillar. These are all there. But what about the attitudinal change? People have to march ahead. We have to towards that destination, from the realm of necessity, we have to take out our country and walk into the realm of freedom. And who will do that? Constitution is there to hold your hand and take you forward, but you should be willing to go forward. That is what I say. Attitudinal change is a must.
Absolutely. And I think that is a very important thought for all of us to take away from. It's not just the government or the judiciary or civil society's responsibility to take the constitution to the people. It's also all of our responsibility to understand and internalize the values, the principles, and the big ideas that our constitution enshrines. And I would have loved to have this discussion for about half an hour longer at least, but we have to close, unfortunately, and hopefully we will get more time and more opportunity to take this discussion forward. So let me once again thank our panelists, Justice Gita, Mittal, Mr. Mander, and Ms. Meira Kumar for having spared an hour of their valuable time to be with us, for having shared these wonderful thoughts. I, for one, have taken away so much from this discussion, and I'm sure so much of our audience has also. Thanks to Aniket Panda and Nitika Gupta for their patient sign language translation for while we were having our discussion. And we're always happy to have their help with us. And also thanks to my colleague Maitri, who has very patiently handled the infrastructure and the back end of all of this. And thank you all for joining in this discussion. Our open house on the Constitution continues. We have more events coming up in the next couple of days. Thank you for joining us today. And I hope you can join us in the coming days as well. Thank you all. Goodbye and have a good evening. Bye-bye.